From WBRN Radio in Boston and on the Boston Red Network. The title of our episode today is Gerrymandering Wisconsin Style. And the case title is Gill versus Whitford. It was argued on Tuesday before the Supreme Court. We'll get to that case in a second, but first of all, let's take care of some baseball news of all things, and this is from the American League playoff was held last night. The final score there was 8-4. The Yankees advance on to Cleveland, and the Twins, the other team, go home for the remainder of the season. Tonight we'll have the National League wild card from the Rockies and the D-backs. Will compete in that wild card to see who will face the Dodgers of Los Angeles. So that is baseball. Baseball, of course, is into now the postseason. We say goodbye to baseball. 163 games, a long trip, plus spring training for those of us that are baseball enthusiasts. No doubt this was a long season, a season that we had the automatic walk, which we decry. We don't care for the automatic walk. Also, we have basic problems with the quote-unquote replay that takes up a lot of time, and it's not necessary. Now, there are some calls that are bad calls by the umps, but again, that is part of baseball. It's sort of like the designated hitter rule, which we have seen with nothing but horror for a number of years. It's not in the National League, fortunately. And when the series is in the National League park, there is no designated hitter. One of the things they did get right last year was the removal of this preposterous scheme whereby the team that won the All-Star game would have home field advantage, of the league, would have home field advantage. Now it will go to the teams. So some of the things out of the way. This will be an interesting season, no doubt. The division in the American League will now between the Yankees and Cleveland. And of course we have the Astros in the West, so that will take off there. So as the week moves along, we'll have more on Major League Baseball, the odds, and various other things that will happen. Now, the Cleveland game, Yankees game on Thursday. So we'll see Thursday, Friday, Saturday action from the National and the American League. And this whole idea of the one-day wild card season, and it is a one-day playoff. It was originally Bud Selig came up with it. Originally they were talking about a 3-game series. Well, it's not a 3-game series, but now we go to the division series, which is the best of 5 games there, and then on to the league championship. And from there we go to the World Series, which will be in the last of October. It's interesting in professional sports now how long we go. Basketball season has started up. Of course, that will go to June. Remember the O.J. Chase from over 20 years ago. O.J. again is a free man now. I'm not sure where he is, but he's somewhere. The juice is on the loose, as H said. So he is out there, and football is out there. The protests continue for social justice. Initiated Mr. Colin Kaepernick, and then it went on to the various teams. Mr. Jones down in Dallas took a knee, and DJ Trump took the wrong side of the issue, and he's still tweeting about it, as he had made more history when he landed in Puerto Rico and said basically Puerto Rico has broken his budget. Well, no doubt about that. He should now start thinking about climate. But on to our episode here on gerrymandering. Very interesting case the court took up today. We'll start with from the Brennan Center. That's at the New York University School of Law. And this is a little bit of history of this case known as Gill versus Whitford. A three-judge federal panel ordered the Wisconsin Legislature to redraw the Assembly's map that the court struck down as unconstitutional partisan gerrymandering by the 1st of November 2017. Last November, the panel declared that the State House plan adopted by the Wisconsin Republican-controlled legislature in 2011 was unconstitutional partisan gerrymandering that violated the Equal Protection Clause and the plaintiff's First Amendment freedom of association. The ruling was the first time in over 3 decades that a federal court invalidated a redistricting plan for partisan bias. They've done it before for race. After evaluating the constitutionality of the map with the three-part test, the panel concluded that the map displayed both bad intent and bad effect, citing the evidence that the map draws used special partisan measurements to ensure that the map maximized the Republicans' advantage in the Assembly seats, despite Democrats winning a majority of statewide Assembly votes in 2012 and 2014. Republicans won 60 of the 99 Assembly seats. Wisconsin Republicans dispute the assertion that they intentionally engineered a bias map, arguing that the partisan skews in the map reflect a natural geographic advantage they have in redistricting as a result of Democrats clustering in cities while Republicans are spread out more evenly throughout the state. Now, this is the rural vote versus the urban vote, which you see across many states. The court, however, said the state's natural political geography does not explain adequately the sizable disparate effect seen in the previous 2 election cycles. The panel, however, denied one of the plaintiffs' principal requests to have judges, not lawmakers or the governor, in charge of redistricting the legislative boundaries, stating in the opinion it's neither necessary nor appropriate for us to embroil the court in the Wisconsin legislature's deliberations. The court advised the panel to use the November ruling as a guide in developing a new districting plan. Wisconsin filed an appeal on the 24th of February 2017, asking the Supreme Court to review the decision. On the 22nd of May, the state court asked the court to stay the panel's order calling for creation of a new plan. On the 19th of June, the Supreme Court announced it would hear oral arguments in the case, and this is where we are now, granted the state's request to stay the decision of the lower court. And the arguments, of course, were held on the 3rd of November. We'll go to Wikipedia here, of all things, just to get a general background of the case. On July the 8th, 2015, the case was filed in district court for the Western District of Wisconsin, arguing that the Wisconsin 2011 legislative or assembly map was unconstitutional. The case was filed by Campaign Legal Center, representing 12 plaintiffs that were registered Democrats. The lead plaintiff was Professor William Whitford of the University of Wisconsin, stated in a democracy, citizens are supposed to choose their legislators. In Wisconsin, legislatures have chosen their voters. The plaintiffs argued that the map violated the 14th Amendment's guarantee of equal protection. Whitford complainant specifically claimed that the redrawn maps purposely diluted Democratic votes so they would be wasted. And we'll get to that in a minute here. And that is cracking the votes while organizing a small number of districts to pick up a larger number of Democratic votes to limit the number of seats the party would win. picking the votes, the district court said was originally filed as Whitford versus Nickel, as Gerald Nichols had become the chairman of the state election board. He was succeeded by Beverly Gill. That's how the case was changed during the course of the case. In 2016, a three-judge federal panel allowed the case to proceed to trial, the first time a case regarding gerrymandering has proceeded in 3 decades, 30 years. On the 21st of November 2016, a 2-1 decision was rendered by the three-judge panel. The map was unconstitutional, and to assert the validity of the map, the panel developed a three-prong test that asked if redistricting intended to place a severe impediment on the effects of votes of individual citizens on the basis of their political affiliation. 2, that the effects, and 3, and cannot be justified on only legitimate legislative grounds. The panel judged these three prongs based on whether they created an entrenchment of power, specifically defined as making that party and therefore the state government impervious to the interests of the citizens affiliated with other political parties, which had been the basis for the unconstitutional gerrymandering in the past. The panel Judge Ripple's opinion, joined by Judge Barbara Crabb, was that the map worked better than its drafters had hoped. It secured for the Republicans a lasting assembly majority. It did so by allocating votes among the newly created districts in such a way that in any likely electoral scenario, the number of Republican seats would not drop below 50%. The panel also used the efficiency gap measure developed in 2014 by a law professor and the lead prosecutor for the panel, Nicholas Stephanopoulos, and a political scientist named Eric McGee. The efficiency gap relates the number of wasted votes for each party across the state, with the gap of 0 equaling to a fair distribution by a definition. An efficiency gap of more than 7% would have allowed the Republicans to retain their advantage throughout the life of the Act 43 map. The panel determined that the efficiency gap was at 13 and 10. In other words, it was 13 in 2012 and 10 in 2014, respectively, exceeding the 7% criteria. Judge Gibback dissented, believing that there was a more appropriate measurement they could take to prevent partisan gerrymandering, such as requiring a non-partisan panel. That's been tried in other states. Gibback also believed that the enrichment of principle would not be accepted by the Supreme Court on over more traditional methods measuring diversion, and that the use of a relatively new efficiency gap measurement miscalculated the nature of a wasted vote. The district court was seen as a potentially satisfying requirement for the tests required by the Supreme Court in the three-judge panel provided by the court, three-prong test, was able to distinguish between the inherent and invidious gerrymandering through a narrowly defined anti-entrenchment principle through the lifetime of the district map. So this is where Wikipedia summed this up, and we'll get back to the actual court. Wasted votes are the basis for computing the efficiency gap, and is measured by the University of Chicago law professor Stephanopoulos and the political scientist in Eric McGee. In 2014, the statistics have been used to quantifiably assess the effects of gerrymandering, the assigning of votes to electoral districts in a way as to increase the number of districts won by one political party at the expense of another. The heart of the calculation is to add up all district votes, the wasted votes of each party. The efficiency gap is the difference between the two parties' wasted votes divided by the number of votes. If a party wins a number of legislative districts in rough proportion to that party's electoral popularity, the efficiency gap will be near zero. Stephanopoulos and McGee argued that in a nonpartisan redistricting, the efficiency gap would be zero with the equal number of wasted votes from each party. If it exceeded 7, then Stephanopoulos and company argued that would ensure the party with the fewest wasted votes would be able to control the state for the duration of the validity of the district map, citing in part the efficiency gap of 11.69% to 13 in favor of the Republicans. District Court ruled. This is back to Whitford and Gill in 2011, drawing mapped the legislature there in Wisconsin. It was the first federal court ruling to strike down redistricting on the grounds of a political party. In the 2012 election, the state legislature Republican candidates had 48.6 of the two-party votes, but won 61% of the 99 districts. So in other words, they had less than 50% of the vote, and they won 61% of the districts. The court found that discrepancy treatment of the Democrats and Republicans violated the First and 14th Amendments. The state has challenged the district court ruling, and of course that went to the Supreme Court. Now, this is the illustration of this efficiency gap. There are two parties, A and B. There are 500 votes divided into 5 districts with 100 votes each. In recent elections, Party A would have 45% of the vote, but won 4 of the 5 districts as followed here. A little example. Let's go to the actual Supreme Court here, and we'll just hear a little bit of this. This is from the Chief Justice of the Court, Mr. Teslian is the Chief Justice. May it please the Court. The Court has, this is on behalf of the appellants. Anyway, the state of Wisconsin. The court has never uncovered the judicial and manageable standard for determining when politicians have acted too politically in drawing district lines. Plaintiffs' social science metrics, and this is back to the equal gap, is composed of statewide votes to seat ratio and hypothetical projections do not solve these problems. Indeed, they would merely shift districts from elected public officials to the federal courts. This is an old argument here. Now, on the threshold matter, this court should hold that federal courts lack jurisdiction to entertain statewide political gerrymandering challenges, leaving for another day the question of district-specific gerrymandering. Justice Kennedy, I think it is true that there is no case that directly helps respondents very strongly on this standing issue. You have a strong argument there. But suppose the court, you would have to assume that we wouldn't know the exact parameters of it, decided that this is a First Amendment issue and not an equal protection issue. Would that change the calculus so that if you were in one part of the state, you had a First Amendment interest in having your party strong or the other party weak? Mr. Teslan. No, it wouldn't, Your Honor. I think the reason for that is even if the First Amendment issue is still grounded in the right to vote, in our country, single district elections, folks only vote their own district. For example, you have some vague interest in the party you associate with having more members in Congress. For example, in Wisconsin, Republicans might have more. Texas a Republican Congress, but no one would say that you have a First Amendment or 14th Amendment right in the sort of circumstance to challenge Texas law that you would, for example, argue that less Republicans from Texas coming to the U.S. Congress. Justice Roberts, well, but I think the argument is pretty straightforward, which you and in your district you have a right to associate. You have a right to exercise the right of association with people elsewhere in the state. And if you can't challenge the districting throughout the state, then your claim seems to be there's no way for you to raise your claim. Justice Kennedy, this of course confines itself to the state and eliminates the problem of out of state. Just the way the Chief Justice stated, hypothetical, Mr. Tesserlin, Tseytytlin. Anyway, well, Your Honor, I don't think it would solve the interstate problem because, of course, the structural relationship, for example, Justice Kennedy, let's assume it does. Well, Your Honor, I still think that this court should be very careful about enacting that kind of doctrine. As you know, race and politics are often correlated in this country. So political gerrymandering claims and racially gerrymandering claims, even if they are ultimately grounded in different constitutional amendments, it would often be raised together. It can be and possibly be that. The reason they're doing it this way in Wisconsin is because they don't have the race amnesty across the state anyway. But if the same map drawer turned on the political stream, then the plaintiffs would get access to the holy grail of a statewide claim. Justice Ginsburg, regarding the question of race, some years ago, this court we'd have to wait on some years ago, this court. Let's see if we find this again. We'll get it in a minute here. With our PDF here. Well, we hope. Here we go. Dealing with that, the so-called Max Black plan said that it was deliberately attempted by the legislature to make as many African American districts as possible. This bears a certain resemblance because the effects here intentionally was to create as many Republican districts. So Max Republicans doesn't it have the same problem that Max Black had now from the Tesla? Well, Your Honor, that turns to an issue of justability, and I do not think that raises the same problem because, of course, politics is not a suspect. This politics is not a suspect of classification like race. And I think the easiest way to see this is to take a look at the chart, and we don't have the chart here. A plaintiff's own expert created, and it's available on supplement anyway. What is striking about the list of 17 is that 10 were neutral drawers. And the court should learn two lessons from the 17 to 10. The first lesson is the partisan symmetry is simply not a neutral districting criteria. This is not a neutral method of drawing districts. For if it were, all of these commissions would not be drawn of partisan symmetry maps. Justice Alito, before you get too deep into the metrics, which I assume you will do in a minute, can I ask you a question about standing along the lines of those asked by my colleagues. Suppose that it was alleged that the town officials in someplace in northern Wisconsin, where the Republican predominates, were discriminating against Democratic candidates for a district, let's say not allowing the candidate to sign up and be put on the ballot. Republicans signed to put up along the roadside, Republican signs, that were pressuring the town. Let's just leave that. Their discrimination with respect to these signs, now that you have standing to raise a First Amendment challenge to that. Would it be just a candidate in the district, or would it be the votes in the district, or could it be voters in any Milwaukee, say Milwaukee, have standing to raise a First Amendment argument? I would certainly think, Your Honor, the candidate would have standing, and I am not sure about the voters in the district, but probably. But certain voters in Milwaukee who didn't vote for the candidate, they would not be eligible to vote for the candidate any more than someone in California. It's interesting to look at some of these arguments here, whether they're justified or not. Let me just skip down here a bit. To Justice Kennedy. I think the question is Ms. Murphy here. It would be who's standing to bring. Justice Kennedy well assumed standing. I like the answer to the question. Yes, it would be unconstitutional if it was on the face of it, but I think that it would be better thought of as probably is an equal protection violation. But you can think of it as well as a First Amendment violation, in the sense that it's a viewpoint of discrimination against the individual who the legislature is saying you have to specifically draw the map to injure. A very complicated case here. Justice Sotomayor comes in. Can you tell me what value it is to democracy for political gerrymandering? How does this help our system of government, Ms. Murphy? Sure. Well, I would point to Justice Sotomayor. You almost conceded that it doesn't, when you say if the state has a constitutional amendment or had a law that says you must simply comply. Oops, a second here. I really don't understand how any of this, what it means. It's okay to stack the deck so it for 10 years, and in definable period of time, one party, even though it gets a minority of the votes, could get a minority of the votes and get the majority of seats. Ms. Murphy, with all due respect, I certainly dispute the premise that the decks are stacked here. And at the end of the day, what matters is how people vote in election. What is going to determine the outcome, as it was in Wisconsin, where the Republicans won majorities because they won the majority of vote in most elections over the past 4 years. Thank you. Justice Roberts, thank you. Oral argument of Paul Smith on behalf of appellees. Anyway, this is him. And let me just go down here and get everything in here. Try to get to the last. So this is the opinion. We always like to do this. We don't say it's complete because, again, it is... I would like to begin by answering Justice Kennedy's question. This is a rebuttal argument here on behalf of appellants. It is a factually discriminatory law in the state that violates the First Amendment because it stigmatizes the party. This case, this court could not be clearer that when you have neutral lines, factually neutral lines, the question is not partisan intent, because there will always be partisan intent. The question is, have the plaintiffs presented a burden on a representative right based upon a limited, precise, judicially amenable standard? There has been nothing new presented to this court. Basically, what the plaintiffs have done here is they've taken Professor King's amicus brief and then taken the same exact central scope partisan asymmetry and then recycled it here. There is nothing new before this court. Secondly, we've heard something about various tests that are now purporting. There was only one test that was subject to adversarial scrutiny. In this case, it was the efficiency gap in a 4-day trial. The efficiency gap tests proved so flatly flawed that the district court rejected it as a test, and the plaintiffs abandoned it as the primary test on appeal. And my final point about scare tactics, about what will happen next, plaintiffs expert did a comprehensive study from 1972, when the Baker redistricting happened, to 2014. And he concluded, you can look at the study, the chart. Anyway, it shows asymmetry was wrong, and was wrong in 72 than in 2014. You're always going to have scare tactics. You're always going to have partisan intent. We have not had any advancement in terms of what's presented to this court. And this whole argument here. And we ask for this reason the court to reverse the district court. Now, where the three-prong test is what the three-judge panel looked at there, but the efficiency gap test is, in our opinion, a very valid test there in terms of wasted votes, etc. Now, the state of Wisconsin does not have an argument here, period. And rebuttal of argument by Misha Seshelin on behalf of the appellants. So in other words, a very long, sort-out case here, how it was laid out. Let's see. Justice Keegan, we have not seen her in this. Because of this seems to me that the map goes over pretty much every line you can name. Smith, that's true. Justice Kagan. But where do you draw the line in another case? In another case, oops. I had not gotten her in here yet, so I'm trying to get her in. Okay. Well, Mr. Smith, well, Justice Kagan, the great virtue of these three different measurements, none of which are presented to the court in VIF. When I argued the VIF case, I didn't do a very good job. Is that each of you allowed me to assign a number to each gerrymander, and that allowed you to compare them across the country and back in history, and therefore it's possible to draw a line. Now, in addition to just measuring the degree of asymmetry, the other thing that's important to do is measure the likelihood of doability of that asymmetry. And you do that with the sensitivity test, saying that you make sure that you don't have the kind of map that with a small swing of voting over the next decade. It's going to flip over the map in Pennsylvania. They actually did another case. We have time tests, and the one now presented to you, we would not have won that case in 2004. But the map is never going to flip over. The evidence is unequivocal that the Democrats would have to have an earthquake of unprecedented proportion to ever have a chance to get 50 votes out of 99. Justice Roberts, all these predictions, I mean, the Bannemeyer predictions that the Democrats would never be able to obtain a majority 50-50 in the next election, and you've got a majority one after that. Wait a minute here. It was 5 days right after the Supreme Court said, I forget, Republicans are never going to get an election. They won every single race, predicting on the basis of statistics that are before us. That had been very hazardous enterprise. Mr. Smith, the technique of sensitivity testing, which was done by the defendant's experts in the process of drawing the map to make certain they were drawing a permanent, non-flippable gerrymandering map here. Mr. Smith, are you suggesting we should be looking for outliners, and are suggesting that we should be trying to filter out all matters of partisan consideration there? Mr. Smith, Your Honor, the word outlier is probably an appropriate one. Certainly we don't think, and we have followed the lead of the court in Justice Kennedy's concurrence and other decisions of the court, that all partisanship is unconstitutional. What you need is a method by which the extreme gerrymandering, the one that is fundamentally anti-democratic, is going to last for a full decade, 10 years, can be identified and held unconstitutional. Now, and that's the only thing we're asking you to do here, Judge Gosham. So, Mr. Smith, that is a formula that, what is the formula that achieves that? Because the court below didn't rely on the efficiency gap. We talked about it earlier entirely. It looked also at a partisan symmetric test. It reminds me a little bit of the steak rub. I like some turmeric. I like a few other ingredients, but I'm not going to tell you about how much of each. And so I guess he's a gourmet today. Anyway, the court is supposed to do is a pinch of this and a pinch of that. Oh, I see what he's doing. Compared to a rub on a steak. I guess he's not a vegetarian. Now, we're supposed to actually to actually specify it going to be the Chief Justice formula or of the efficiency gap of 7% for the country. Is that what you're asking us to do? Is it that what you want us to constitutionalize? Mr. Smith, Your Honor, the first thing we want to make clear is that the symmetry is what is being measured by the efficiency gap and by the other two tests that I mentioned. Symmetry is the underlying substantive. Justice Gorsham, well, there are different tests for measuring symmetry. Right. Mr. Smith, right, there are. Judge Gorsham, these tests you previously purported, now there's the efficiency gap test, and the court relies on both for a little bit, a pinch of this and a pinch of that. We're back to that again. Anyway, Mr. Smith, well, yeah, I think it's fair, Gosham. So that doesn't seem very fair to the states that what they were supposed to do is avoid the kind of litigation we are talking about. As I understand the efficiency gap test itself, and tell me that if I'm wrong, that it would yield about a third of the districts in the country winding up in court. Not true, not true. Now, that's what the other side says. So tell me where that is wrong, and tell me that the test you have this court adopt. Well, first of all, I would go with the screens that Justice Breyer mentioned. The first one being is to have has to be a one-party state. There is a one-third figure they are throwing around, ignores the fact that the numbers of these maps were drawn either by commissions or by courts of divided legislatures. And so they get all these take off the table from the very beginning. If you have a one-party state, you then have to measure whether it's unusually asymmetrical or pretty extreme. Judge Gosham, how? I'm still stuck on Justice Breyer's question, Mr. Smith. You can use any of these three tests. They all apply. Any of them? Yes. Any of the three? And if you don't, I would suggest you apply all three. Judge Gosham, all three of them. Mr. Smith, if they disagree, that they would tell you maybe this isn't the right case to be holding something unconstitutional. That might be a fly in the ointment, but the court below did not set. Judge Alito, excuse me, isn't it true, Mr. Smith? The line, I'm sorry, Justice Alito, on that, it isn't true. You can get a very high level of and a very high e.g. Based on factors that have nothing to do with gerrymandering. The political geography can lead to it. Protection of incumbents, which have been said to be legitimate factors, it can lead to a high EQ. Complying with the Voting Rights Act can that affect. Mr. Smith, certainly there are various factors that and that others than the partisan bias test that can lead to draw a map that does not have a zero EQ. As the gap. Our test of the intent, the effects require, and the problems are taken either at the intent stage or at the justification stage. How are you going to take the case at the justification stage? The purpose is to run many, millions of and eternity maps to see whether using some traditional districting requirements you can produce a map that has a lower EG, as they're now calling it. And, Your Honor, I would say that this is the remedy stage. If you come back with a remedy map that matches the sort of neutral geography, even if it is somewhat favorable to the party that's in charge, you should be okay. It doesn't have to be zero. Now, that's very important. It doesn't have to be zero. It could be up to a 7. There's nothing written in stone, but it has to be a 0. Mr. Smith, Your Honor, I think that there's a majority. One party has a majority in both houses of the legislature and the government. The fact there are some representatives of the other party in minority status would not negate the possibility of that there. And that's George Gorsham appears again here. Is that the Republican form of government claims, Mr. Smith, I think a First Amendment claim and equal protection claim. I am not trying here to review the Republican form of government clause at its last stage. George Gorsham, isn't that exactly what you're trying to do? It's just silly. No. You are saying it is a one-party rule and that would violate the Republican form of government. Guarantee Wouldn't that be a more specific constitutional provision to look at rather than at the generic equal protection clause? Well, for that matter, maybe we could just for a second talk about the acute nature of the Constitution. Well, it's just silly. What exactly where exactly do we get the authority to revise state legislative lines when the Constitution authorizes the federal government to step in only on states, but legislative matters is pretty clear. Subject to final. First, look at the First Amendment. You look at the 19th Amendment, the 26th Amendment, and even the 14th Amendment. Section 2 says Congress has the power when the state legislature do not provide a right to equal votes to dilute the congressional representation. Aren't these all textual indications in the Constitution itself that we maybe we ought to be cautious about stepping in? Mr. Smith, well, I don't think there's anything unusual about using the First Amendment and the 14th Amendment to regulate abusive management of state elections by state government. And that's what the court has been doing. Justice Ginsburg, where did the one person, one vote come from? That was Reynolds versus Sims, Baker versus Carr. Been around a long time, and a number of other cases that followed along the same sense. Whoops. And the fact that Congress has conceivably regulated this problem under the 14th Amendment does not mean the court should not. There are a number of cases. The terms limit cases. Cook versus Gill, where Congress could use the election clause to fix the problem, but the court said, well, in the absence of congressional action, we're going to regulate an abusive, a misuse of power to run federal elections. And let me finish this up. Judge Gorsham, do you see any impediment to Congress acting in this area, other than the fact that politicians are never going to fix gerrymandering? They like gerrymandering. This is from Mr. Smith. The voters of Wisconsin can't get on the ballot without the legislative consent. That is true in both the state, and that doesn't have a commission now. So we are here telling you, like the gerrymandering, this is subject to final review. You are the only institution in the U.S., this is Mr. Smith, that can solve the problem, such as democracy is about to get worse because of the way gerrymandering is going to get worse. Justice Alito, you paint a very dreary picture about gerrymandering, its effects. We talked about this earlier, Mr. McGee, and he said, I'll show the effects of party control bias as small and decays rapidly, suggesting that redistricting at best is a blunt tool for promoting partisan interest. So he was wrong in that. He was right with that. Well, anyway, Your Honor, I see what the sentence is saying in the context. I'm quite confident Mr. McGee does not think that redistricting is not and is a non-problem. Anyway, we'll finish it up here. That is the case here that has changed its name a number of times, but it's known as Beverly Gill. She is the appellate versus William Whitford. He is the appellee, and in the United States Supreme Court. So that finishes that case. We'll ran a little bit over time here. Just take a quick look at the Washington Post. The events in Las Vegas are ongoing. That supposedly the gunman meticulously planned what he was doing, and he carried it out there at the hotel. And what leads, it's kind of an ongoing, more of a soap operic type of situation. Other news: no plans to bring a gun silencer bill to the House floor. That is from little Paulie Ryan, the Speaker of the House. So this thing is very hot, and at the same time, DJ Trump was about a disaster in Puerto Rico, blaming the Puerto Ricans for, as he called it, bursting his budget. Is America ready for Charlie Hebdo? The French Weekly is launching a U.S. Project. Remember him in the cartoon. And let me see what else we can conjure up here. I guess that's all we can conjure up here. We'll take a quick look at Reuters. Oops. Oh, the girlfriend of Mr. what was his name? Anyway, has arrived in Los Angeles from the Philippines, where she was. And they'll try to get various information out of her. Criticism of the current tax plan come from Mr. Warren Buffett, Berkshire Hathaway there, and BlackRock, who is that? Larry Fix, I think it was there. Fix said the corporate rate as high as 27% could satisfy American businesses and needs relief from taxes while avoiding an increase in the federal deficit. That is their concern. Here, Mr. Buffett, the chairman and CEO of Berkshire Hathaway, we have a lot of businesses. I don't think any of them are non-competitive in the world because of the corporate rate. And Berkshire Hathaway does have a lot of businesses. The GOP plan unveiled this month calls for slashing the corporate rate to 20% from its current 35% to 15% decrease. The plan contains up to $6 trillion in tax cuts. That's according to independent analysis. We had a program on that. You can go back and where we talked about that particular situation. This is a second issue. Gerrymandering is very, very big. And we have another case coming up in the Supreme Court involving unions. We'll review it also. Analysts who testified, Senate said, hearing said only 20% of the benefits of corporate tax would directly help workers. This thing is just a gimmick here. House Ways and Means Committee. This is Kevin Brady. He's always there when Dr. Yellen testifies, along with our own Maxine Waters. We've kicked around 6, 8, 10 different types of options. Anyway, this. One of the things there, from the business leaders, these criticisms are coming. They are coming from all kinds of people, community organizations, etc. So we're seeing a lot of criticism. Let's look at the polling here. We had some polling out of Alabama. Judge Moore and Jones, that race there. Vice President Biden was there. The Democrats hadn't really put any money in. This is JMC Analytics. Judge Moore 48 to Jones 48 point advantage there. And what is this poll here? Oh, out of Jersey. This is Murphy's ahead by 14 in Jersey. There was another Roy Moore poll here. Up by 5%. Opinion Sabi, that was on last Friday. Those are the only ones we have. So in other words, somewhere between 5 and 8% is Judge Moore. Will the Democratic Party put any money into Alabama. Well, that's a very interesting situation there. There have been various arguments that they should do it as they say, the only way that a party can gain ground in a very red state like Alabama, they have to run statewide races. So people will become accustomed to seeing the party and its standard bearers out there. That's one of the things that has to happen. Of course, obviously, funds are limited. So how do we manage limited funds? And progressives in general, all over this country, will start doing some programs in the coming days and weeks leading up to November in some of these cities out there, like Ms. Moon out in Seattle is running as a progressive out there. And then we have other cities that progressive candidates, but some of them are slew, like in Minnesota, in Minneapolis, and the Twin Cities of St. Paul. There are some progressives running, but there are several progressives running, so we need to figure out some way to do that. We don't really have any polling now. The Seattle race is a little bit different. We've been working on Seattle for quite some time. And we also intend here at WBRN to start to bring our BR on the World. That's our international program up to date as we start covering various things. For instance, in Australia and other areas of the world. Catalonia, there's a crisis there in Catalonia. They have voted for independence. We'll look at Catalonia. We still need to go back and look at some of the speeches from the UN. We're a little behind on that. And the open source report, we're about 50% finished on it. What has happened is it's been several weeks, so some of the items have to be taken out, others have to be put in. But Equifax, we'll come up on Equifax and what happened there. And incidentally, Equifax got 7 point whatever $1 million bid. I think it was $1 million bid to, of all things, provide information to the IRS. It was one of those bids that is a solo bid. There were no other competitors in it, and so we'll see where that goes. Incidentally, from Yahoo, and this is back to 2003, 3 billion accounts were hacked there. We never got the numbers out. And a lot of these numbers are ongoing. There's no doubt about that. And I was looking to see if we see the Equifax thing. It may have disappeared off of Reuters for the time being. But it will, as they say, pop back somewhere here. More from Wisconsin and Michigan were key targets of the Russian ads, cyberspace ads. So those things are going on. Reuters has Justice Kennedy on the hot seat. That's our program we just completed here. He is the swing vote and could be the person to actually fashion the vote in the Supreme Court one way or the other on dealing with political Catalonia. This is from the BBC. That Independence Day is coming up very, very quickly. And we already talked about DJ Trump in Puerto Rico, comparing the deaths there. He's saying, well, there are less deaths. I think there's 35 or so there as opposed to Katrina. There's 1,500. Well, you really can't compare the two. That doesn't work out as well there. But you can compare response to it and how the respondents will happen. Now, in Catalonia, a little bit about the Spanish king, comments came there. He doesn't have a function as far as I know. So in other words, on it goes. I talked to a woman today who was actually, her parents live in Catalonia. Kind of interesting situation there. We'll have more on that story. Anyway, this will do it for us. Good day, and the champion, the playoff baseball tomorrow night in Arizona, and the Rockies, and I believe they play in Arizona. Don't quote me on this. I'd have to look it up.